Every single day, people are injured at work or on the job through no fault of their own, and this is why workers' compensation system was even created. However, while the system was meant to protect employees, it's often stacked against them. Oklahoma law states that if you get injured at work, your employer is not responsible, but their insurance company is. However, the problem is the law is complicated and confusing to navigate, which leaves many people not getting the proper treatment or compensation they need. And this is why you need skilled representation. I'm Craig Armstrong, and since 1983, I've been helping Oklahoma residents whom are injured at work get the proper compensation they are entitled to. When you file a claim, you need to do two things. First, prove you meet the requirement, and secondly, that your disability or injury occurred at work or on the job. The insurance company is who your claim is against, not your employer. But it's important to understand one thing: they are not on your side. They have an army of lawyers with one goal in mind: limit the amount of compensation you receive, and that's why people hire an attorney. Workers' compensation is a no-fault system that has been set by statute. It is a method in which injured workers can receive compensation in the form of medical treatment and potential income benefits while they were recovering from an injury. It was set up because in the Industrial Revolution in the early 19th century, there were no workers' compensation laws. Employees were being injured at work, and they had no recourse to get medical treatment or to be compensated for any of the income they were losing. States developed workers' compensation laws that allowed access to medical care and other benefits, but with one catch: you could not sue your employer. It became a no-fault system where you could not allege negligence, but you were entitled to medical treatment regardless of fault. Now, depending on your specific case, your compensation can vary, but in either case, you need to prove the extent and damages of your injury suffered. No differently when someone is convicted of a crime. The lawyer has to prove they are innocent. Well, when you're injured at work, your lawyer needs to prove you've been injured at work through no fault of your own. If you're filing a claim, speak to an attorney immediately. It's in your best interest. Contact my firm and we can walk you through how everything works. Secondly, seek medical treatment as soon as possible, if not already, and make sure you document everything. And third, don't give any written statements until you have spoken to an attorney. Working with our firm doesn't cost you anything out of pocket, as all our cases are taken on a contingency basis, which means we only get paid if we successfully win your case. This places a burden on us to win your case, not you. We will provide you with everything you need to know or do throughout the process to make sure we have a winnable case. Unlike working with a large firm where you're just another file in a stack, handed off to staff members who juggle hundreds of files, I personally handle every case. It's essential that your case is getting the attention it needs. You don't want to end up with a settlement that's far less than you deserve because your lawyer is more focused on closing cases than getting you justice. If you've been injured at work, schedule a call with us today and let us help create a plan to get you the compensation you're really entitled to receive. I'm Craig Armstrong, and myself and my law firm look forward to helping you through this entire process.